Being an executor is like being a conductor of an orchestra, but instead of music, you're orchestrating the final financial affairs of someone's life. It's a role that requires coordination, diligence, and a deep understanding of legal and financial matters. To give you an idea of how important the executor is, this is an example of what the executor has to do when someone passes away. So the executor has to organize a funeral, has to organize burial, cremation, has to arrange payment for the funeral expenses. The executor has to work out if there was a will, where the will is. The executor has to identify the assets, and if there are any debts, they have to seek advice, whether it's from financial or legal, to apply for probate. Even before probate is obtained, the executor, if there are any challenges to your will and to your estate, the executor has to defend those challenges. Once probate has been granted, the executor then has the responsibility to make sure the assets are distributed in accordance to your will. And finally, the executor has to file tax returns and provide distribution statements. So you can see how everything after you pass away to do with your assets and to do with the executor's responsibility. Probate is the legal mechanism where a court grants control and administration of your estate to your executor. So only when you obtain probate, which is a court-provided document, and you then go to banks to close accounts or to withdraw monies, to sell shares, to sell property. Without probate, then nothing can be done in relation to those estates. So probate is only made on the grounds that there is a will. So the first step is to collect all of the legal and financial information of the deceased, and that includes the will, list of the assets, list of the properties, bank account statements. The second step is to publish a notice of the intention to apply for probate, and you must wait 14 days after you publish a notice. So the reason you have to announce that you're applying for probate is to give people time to raise any objections. For example, if people think that the will is not valid, or if they're contesting the validity of a will or contesting some other aspect of the will. Applying for probate is a formal application that you have to make with the Supreme Court of New South Wales. And to do so, you will have to provide supporting evidence to the court, including the will, the death certificate, supporting documents, and supporting evidence to the court. Once you've applied for probate, there is a time period that the court will go through your probate application. They will raise any questions in the form of requisitions, and then as executor, you will have to respond to those requisitions. The final step is the grant of probate by the court. This means that the court is now satisfied. Probate should be granted to you as an executor, and will give you a formal record of the grant of probate that you can then use to gather in the assets. So you can then use this document with banks, financial institutions, insurers to sell property. After the court grants probate, there are important steps that an executor must follow. These steps are, first one is actually to wait 6 months after deceased has passed. The second step is that you'll put an advertisement that you will start distributing the assets after 30 days. The executor will then need to pay expenses and debts of the deceased. The executor, before then distributing the assets, must not be put on notice of any potential family provisions claims. If they are on notice of that, they must not make any distribution. And then once all of those steps are followed, the executor can start distributing assets and will need to account for the distribution as well as file tax returns.
What happens if there are disputes or conflicts among beneficiaries during the probate process?
That's a very good question, as disputes can invariably arise. There's quite a funny adage, which is where there is a will, there is a relative. And there are often times where a person believes that they weren't adequately provided for. The best way for the executor to deal with these issues is to get the advice of accountants, get the advice of the lawyers. And through that advice, the executor will need to work out how strong these claims are, whether it is worth fighting these claims in court, which can be a long, arduous process, also very costly because those costs will need to be funded out of the estate, or whether it is better to come to some arrangement at that family member through mediation, some form of negotiation and settlement, because that could be more efficient and effective way of dealing with a dispute. So it's very important to use an executor that you trust, that also has the capability of managing your estate, dealing with the legal affairs and dealing with the financial affairs. It's important to know that the executor is not alone in this journey. The executor has the ability in a well-drafted will to deal with any disputes, and the executor will to utilize the services of trusted advisors, such as financial planners to manage the money, of accountants to deal with tax obligations under the estate, and also lawyers who will navigate and help them navigate through this probate process and the distribution process.